Case 51, United States v. Starcher. We find ourselves here in the U.S. District Courts for the Middle District of Florida. Facts. Defendant Starcher was indicted on May 18, 2011 and arrested on May 25, 2011 for criminal drug conspiracy activity that took place from May 2009 to January 2010. Prior to the indictment, in October 2010, Homeland Security Investigations agents seized a Cessna 206 aircraft, tail number 8065 Zulu, from a private residence located on Sand Lake Shores Court in Orlando, Florida, for violations of 49 U.S. Code 46306. Those are registration violations. Petitioners do not own the residence. The owner of the residence is a friend of defendant Starcher's who agreed to allow him to keep the aircraft on his property. The work that was performed on the aircraft to make it seaplane ready between approximately March to May 2010 was conducted in Gobles, Michigan, by a mechanic hired by petitioner. Petitioners had direct authority in overseeing the work performed by the mechanic and were monetarily responsible for all work completed by the mechanic during that time period. After the work was completed in Michigan, the plane was returned to Florida and kept at defendant's friend's residence. Petitioners do not maintain that they had actual possession of the aircraft, either before or after the repairs to the plane were made in Michigan. On October 3, 2011, defendant Randall Starcher pled guilty to conspiracy to possess with intent to distribute marijuana in violation of 21 U.S. Code 841. Defendant entered into a plea agreement, which required him to forfeit all of his interest in any and all property constituting or derived from proceeds traceable to the offense, including the aircraft titled in the name of Mile High Adventures. Starcher agreed to forfeit the aircraft, admitting that it was used to facilitate drug offenses that were committed between May 2009 and January 2010, and that the aircraft was purchased with proceeds obtained from the drug conspiracy. The government sought a preliminary order of forfeiture, which the court granted on November 3, 2011. The court required the government to notify in writing all known third parties who allegedly had a legal interest in the aircraft. On December 6, 2011, petitioners received a written notice of forfeiture to the aircraft, to which they filed timely a claim alleging that they had 50% ownership. Petitioners assert that they entered an oral conditional sale agreement with defendants on behalf of Mile High Adventures. They alleged the oral conditional agreement provided that if petitioners spent money and labor to convert the aircraft into a seaplane, in return, Mile High Adventures would provide sightseeing services to tourists and give a 50% interest in the aircraft to petitioners. Petitioners assert that in May 2010, they completed their obligations under the verbal conditional sale agreement. According to FAA records, on May 23, 2009, Webb Thomas Aircraft Sales sold the subject aircraft to Mile High Adventures, and the bill of sale and aircraft registration application were filed at the FAA registry on May 29, 2009. However, because Mile High Adventures' bill of sale failed to properly provide proof of its United States citizenship, the company never obtained a certificate of aircraft registration from the FAA. According to Special Agent Steve Tuckerman of the FAA, a review of FAA aircraft registration records indicates that no other documents evidencing a conveyance of the aircraft by petitioners or anyone else have been submitted and or recorded at the FAA registry since May or June of 2009, when Mile High Adventures submitted its paperwork to the FAA. So what's the issue? Whether petitioners perfected any interest they might have had in the aircraft in compliance with federal and state regulations, and as unsecured creditors, they qualify as bona fide purchasers. Holding. The court recommended that the government's motion to dismiss be granted and the petition be denied. Reasoning. As the Supreme Court has held, every aircraft transfer must be evidenced by an instrument, and every such instrument must be recorded before the rights of innocent third parties can be affected. Given the circumstances before the court in this case, petitioners failed to perfect any interest they might have had in the aircraft in compliance with federal and state regulations, and as unsecured creditors, they do not qualify as bona fide purchasers. Here, under 21 U.S. Code 854, the Hoots were required to establish by a preponderance of evidence that they have a legal right to the airplane that renders the forfeiture order invalid. Petitioners failed to reduce their oral conditional sale agreement with defendant Starcher into writing. Although petitioners spent time and money, approximately $35,000, to convert the airplane into a seaplane under 44108, the oral conditional agreement would not be an enforceable interest against third parties because a written instrument was never executed or recorded. Thus, according to the court, the petitioners acquired no legal interest through their transaction with defendant preceding the forfeiture. The bulk of the Hoots' remaining argument is that rather than acquiring a legal interest in the aircraft before the conspiracy, they acquired an interest in the aircraft after the criminal activity as bona fide purchasers for value as defined in Section 853. In order to qualify as a bona fide purchaser for value under the language of the statute, a person must not have known that the property purchased was subject to forfeiture. The Hoots did not assert their written claim or lien to the airplane until after the government had published the notice of forfeiture and provided notice to petitioners directly. Any registration or lien on the airplane that petitioners would file at this juncture would clearly be after petitioners learned of the forfeiture and negates any objectively reasonable belief that they have in the property. Petitioners failed to perfect any interest they might have had in the aircraft in compliance with federal and state regulations, and as unsecured creditors, they do not qualify as bona fide purchasers.